Okay, I think I'm probably live at this point. Really live. Going to be reading, like I said, I'm not skipping the introduction. I'm going directly into the California Appellate Practice section titled Table of Statutes and Rules. In the description, there's a whole host of different citations, and this section reads as just the citation without any content. So I'm having to look it up. We're going to begin with the California Constitution, Article 1, Section 13, which was just opened. Article 1 begins with inalienable rights, reproductive freedom, liberty of speech or of the press, responsibility for abuse, right to refuse to disclose source of information by member of news media, right to instruct representatives, petition an assembly, right of access to government information, religious liberty, military subordinate to civil power, standing army, quartering in houses, slavery, involuntary servitude, due process and equal protection, pupil, school assignment or transportation, privileges and immunities, due process and equal protection, same actual title, marriage, validity and recognition, business profession, vocation or employment, sex, race, creed, color, or national or ethnic origin, bill of attainder, ex post facto laws, obligation of contracts. 10, detention of witnesses, imprisonment for debt, tort, or militia, fine, habeas corpus, suspension, bail, Section 12, bail release exception for certain crimes, excessive bail, recognizance, searches, and seizures warrant is Section 13, which is where we are perhaps, going to start. However, before I go there, I just wanted to read habeas corpus as it's related to a job I applied for. It's a very short section, Section 11. Habeas corpus may not be suspended unless required by public safety in cases of rebellion or invasion. Going to Section 13, we are reading about, we're skipping bail, excessive bailment, and going to search and seizures and warrant. So Section 13, the right of the people to be secure of their persons, houses, papers, and effects against unreasonable seizures and searches may not be violated, and a warrant may not issue except on probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons and things to be seized. So how this relates to appellate jurisdiction, appellate practice, I'm not entirely sure, but this is searches, seizures, and warrant. I'm going to read it one more time to see if I can't relate it. There's also within this Article 1, Section 13, Section 9.36, but I'm not seeing that in Westlaw, so I don't know what to do with that subtext, in-text citation. So reading it again, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable seizures and searches may not be violated, and a warrant may not issue except on probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons and things to be seized. So I'm wondering if in this appellate practice book that this rule is being suggested for potentially appealing a warrant, the validity of a warrant that's issued by the lower court, the municipal court. That might be why this is here. There really isn't a lot. Oh, wow. There's 4,754 notes of decisions that are actually hidden. So we're not going to go into all that because there's a lot of statutes here. We're going to float to Article 4. Now within Article 1, there's yet another 19 more sections. So the death penalties here, due process, speedy trial, joining criminal cases, discrimination in public employment, education, contracting, public safety and rehabilitation act, non-citizens, husband and wife separate property, right to vote or hold office, not conditional property qualification, grand jury, something setting it apart from the federal constitution, treason, cruel and unusual punishment, jury trial, criminal cases, felony, prosecuted by indictment, post-indictment, preliminary hearing, non-citizens, property. So Article 2 involves voting, initiative, and referendum and recall. Article 3 involves the state of California. Article 4 is legislative. Article 4A, redistricting, which was rejected. Article 5, executive. Article 6 is actually what this Roman numeral is, and it's judicial. So I'm going to open that up because the rest of the citations in the not unreasonably are from this section. The appellate practice table and statutes come from this section. So there's quite a bit of sections here. Many of them are repealed. What we're going to read is 1A, repealed. So we'll just read 1 in this case, because 1A is repealed. So 1 is the judicial power, courts of record, and the section reads, the judicial power of the state is vested in the Supreme Court, courts of appeal, and superior courts, all of which are courts of record. So there's your authority. 1A is repealed, and it doesn't even actually say what it was. There was a red flag negative treatment cause for the repeal. So I'm floating on to Section 2 of Article 6. Supreme Court justices, times for convening, concurrence required for judgment, acting Chief Justice. Ooh, I wanted to actually save this language in a separate document. Like, I've made a folder in Westlaw, but actually making a handbook as well. Now, this section reads, the Supreme Court consists of the Chief Justice of California and 6 associate justices. The Chief Justice may convene the court at any time. Concurrence of 4 judges present at the argument is necessary for a judgment. An acting Chief Justice shall perform all functions of the Chief Justice when the Chief Justice is absent or unable to act. The Chief Justice, or if the Chief Justice fails to do so, the court shall select an associate justice as acting Chief Justice. Wait. It's like water. That was Section 2. Moving on to Section 4. This was repealed, but it's authority. And this one was like Supreme Court, basically calendar and convening. Superior Court's officers and employees appellate divisions. This is section 4 of Article 6. Section 4, in each county there is a superior court of one or more judges. The legislature shall prescribe the number of judges and provide for the officers and employees of each superior court. If the governing body of each affected county concurs, the legislature may provide that one or more judges serve more than one superior court. In each superior court, there is an appellate division. The Chief Justice shall assign judges to the appellate division for specified terms pursuant to rules not inconsistent with statute adopted by the Judicial Council to promote the independence of the appellate division. So I'm writing here appellate appointment, but I'm going to read it again. In each county, there is a superior court of one or more judges. The legislature shall prescribe the number of judges and provide for the officers and employees of each superior court. If the governing body of each affected county concurs, the legislature may provide that one or more judges serve more than one superior court. Which now is a great time to question, what does pro tem mean? Appointment. What does a pro tem mean? Temporare, for the time being. The Latin phrase for the time being is often used with an office or a role to indicate a person serving in that position is there temporarily or as a substitute, not as a permanent or duplicate. For example, a judge pro tem is a judge who acts for a regular judge who is absent, sick, or disqualified. A president pro tem is a person who acts in place of a president of a legislative body, such as the U.S. Senate, when the president is unavailable. Oh my God. All right, let's move on. I'm just backing up my lovely library / tweeting the definition of pro tem. For A, for B, for C, for D, for E. Let's see if these are all still in existence. Repealed. For A through 4 3/4. Which I see here actually, I was supposed to read through 4A to 4 3/4. And it's all been repealed in 1966. And this book that I am reading from, I believe, was published in 1960, which is why that is going to be the case with some of this. A little bit of simplification going on for lawyers like me. I can't keep track of hundreds of years of citations with these. 1966. So that's so interesting. This was repealed at the very time, same year that the book is published. So the last section from Article 6 and the last section of the California Constitution that we're reading is Section 24. So I'll go to the table of contents to get there. Before I do, I'll read what still exists here. There's the Judicial Council, Section 6, Section 7, Commission of Judicial Appointments, Commission on Judicial Performance, State Bar, Public Corporation and Membership. 10, Jurisdiction, Habeas Corpus, and Proceedings for Extraordinary Relief, Jurisdiction of Superior Courts, Comments on Evidence and Credibility of Witness. I believe I'm going to read this too. Section 11 is Appellate Jurisdiction. I think that ought to be read as well, but that actually ought to be cited here because perhaps it replaces what was removed from Section 4, and it's clearly part of the appellate practice to be reading the appellate jurisdiction section. So let's just start with habeas corpus. Like I said, applied for a job involving habeas corpus in California. Jurisdiction, habeas corpus, and proceedings for extraordinary relief. Original jurisdiction for superior courts, comments on evidence and credibility of witnesses. If you remember, the court shall not deny it except in times of extraordinary, like war or insecurity. Here we have Section 10, the Supreme Court, Courts of Appeal, Superior Courts, and their judges have original jurisdiction in habeas corpus proceedings. Those courts also have original jurisdiction in proceedings for extraordinary relief in the nature of mandamus, certiorari, and prohibition. The Appellate Division of the Superior Court has original jurisdiction in proceedings for extraordinary relief in the nature of mandamus, certiorari, and prohibition directed to the Superior Court and causes subject to its appellate jurisdiction. Superior courts have original jurisdiction in all other causes. The court may make any comment on the evidence and the testimony and credibility of any witness as in its opinion is necessary for the proper determination of the case. So this gives a lot of discretion, but the appellate division, this is what's key to this text right now, is the third sentence. The appellate division of the Superior Court has original jurisdiction in proceedings for extraordinary relief in the nature of mandamus, certiorari, and prohibition directed to the Superior Court and causes subject to its appellate jurisdiction. When it says mandamus, actually it doesn't say habeas corpus, which is strange. I would think that the appellate jurisdiction has jurisdiction over habeas. Is habeas a kind of mandamus? Hey Siri, is habeas corpus a kind of proceeding that falls under mandamus, a writ of mandamus? Habeas corpus is recourse in law through which a person can report an unlawful detention or imprisonment to a court and request the court order, which might be the writ of mandamus, court order the custodian of the person, usually the prison personnel, to bring the prisoner to court to determine whether the detention is lawful. So I think when you say writ of mandamus, hey Siri, does writ of mandamus include habeas corpus proceedings? A writ of habeas corpus is a judicial mandate to prison officials ordering, I think it's a writ of mandamus. So there. Appellate courts have jurisdiction over habeas corpus. Next. Prohibition and cert. Okay. And what are they calling these? Appellate Division of Superior Court. Not every jurisdiction has that. So, like a superior court. Made of a trial court, appeal, and supreme. Here it's superior, I suppose, appellate and supreme. But that's how you refer to it, I would think. So moving on, because I just read 11, Supreme Court transfer of causes, review of court or appeals decisions, reversal or error resulting in miscarriage of justice. I mean, so these are really relevant. I don't know why. I mean, I would venture to say that these probably have been published after 1966. Yes, added in November of 1966. So this replaces article or builds on after Article 6, Section 4 was repealed. So Article 12 would be the Supreme Court jurisdiction. Not sure it's necessary to check that out. Article 13, reversing an error for miscarriage of justice. That's worth reading. Because if you remember just from the preface, the authors were saying that's really the only time that an appeal is worth making justiciable. They say here, no judgment shall be set aside or new trial granted in any cause on the ground of misdirection of the jury or of the improper administration or rejection of evidence, or for any error as to any matter of pleading, or for any error as to any matter of procedure, unless, after an examination of the entire cause, including the evidence, the court shall be of the opinion that the error complained of has resulted in a miscarriage of justice. So that's why under any circumstances, that's the only time you would even bring an appeal. Short of that, you don't have one. So let's copy section 11 in here. And section 1. Section 11. This was section 10, not 11. The habeas corpus was 10. I didn't read 11. Let's move to 11 quickly. Did I not read? I read 11 because it had to do with Appellate Division of Superior Court. It was like outlining the jurisdiction. Okay. Appellate jurisdiction. There you go. I can kind of believe that this book and the changes to the Constitution are at the same time. But I can only believe that because, I mean, it's through these kinds of books that, like, thought leadership would be received by the legislature and actions taken. So I don't know, it probably is related to the fact and that this was published, but that's very quick response from the legislature. If it was a proponent for changes to the Constitution. California Constitution, let's call it Appellate Division or practice. Okay. The handbook, available to anyone interested. Since we're recording the compilation of it. So, I'm just going to continue reading through. We're talking about judges of courts of record, qualifications, election of judges' term vacancy, judges' eligibility for other offices or positions, fines or fees, retirement credit, judges' disqualification, suspension, retirement, formal proceedings, rules, commission on judicial performance, subordinate judicial officers, oversight and discipline, commission on judicial performance, disciplinary action, disclosure of tax limitations, judges' compensation. It's interesting because business... No, I'll take that back. This isn't interesting. Where was I? we read miscarriage of justice, okay, and the Supreme Court hears appeals, and I'll copy it into my handbook, but where are we? We're at temporary judges. Wow, section 21. Judges' retirement causes, judges' compensation. I think that's what we just read. Trial courts of record officers to perform subordinate judicial duties. Then everything else was repealed, including section 24 that I was going to read. Which is weird. Yeah, it was repealed the same year this book was published. Wow. Okay. Everything above was repealed. I mean, these are some court requirements. The legislature may provide for the appointment of trial courts of record of officers such as commissioners to perform subordinate judicial duties. Now, I'm going to just venture to assume that the reason I'm reading this and maybe some of the sections like the temporary judge, while I think it's important to know whether or not these temporary judge decisions can be appealed or the trial court of record. I have a question, I guess. Probably not take up a lot of time. The answer is probably in the affirmative. I say appealable because, like, is it part of the jurisdiction that I read about, or the appellate jurisdiction I earlier read about? But anyway, we're not going to labor this any longer. That is all that is going to be read about the California Constitution at this point. The remainder of the Constitution, as it may be of interest to, say, new practicing lawyers. There are another 36, okay. It goes up to Article 36. We're Article 6 right now. So there's another 30 articles that enter into the discussion of reapportionment of Senate, Assembly, Board of Equalization, and U.S. House of Representatives, which was rejected. Public officers and employees, militia, repealed, education, water resources development, Marine Resources Protection Act of 1990, local government, community strategic action plans, rejected, public utilities taxation, tax limitation, government spending limitation, voter approval for local tax levies, assessment and property-related fee reform, local taxpayers and Public Safety Protection Act rejected, labor relations, usury, public finance, infrastructure investment fund rejected, land and homestead exception repealed, amending and revising the Constitution, motor vehicle revenues, loans from the public transportation account or local transportation funds, motor vehicle fuel sales tax revenues, and transportation improvement funding, termination of unlawful taking or diversion of revenues from specified funds, more about vehicles, miscellaneous, redistricting, Senate, Assembly, Congressional. This one probably was not rejected. That was rejected. Government contracts for architectural and engineering services in current. This one was repealed, rejected, renumbered, repealed. Like the blind, public officers, civil services, state employee relations, open space conservation repealed, revenue control and tax reduction rejected, public housing project law, medical research, and clean alternative energy program rejected. So, one thing I think might be worth looking at is so many of them pertain to like the environment. So environmental law interests might actually get their direction from going to the Constitution and looking at rules, notes on cases. That site there. Because in my mind, since I do some advocacy work in the area of environmental law, in my mind, I'd like to know why some of the articles were repealed and or rejected. And some of them, like, marine, what was that? Without going too far into the wrong direction, talking about Marine Resources Protection Act, like, there's a lot of sections in here. Gill or trammel use, surrender of permits to use nets in protection zones, ecology reserves in ocean waters to protect wildlife, severability of article provisions, report to legislators, scientific research, surrender. So probably not relevant, but I mean, I'm wondering if there could be some premise in here for maybe why the military didn't clean up some of the Superfund sites. Maybe they gave themselves an excuse in the Constitution. Since there's so many sections in there worth taking a look at that tend to unravel into a lot of subsections. So moving on, the next areas that we are going to look at include all of a various number of California statutes. If you look at the description, you'll see that the first one is Business and Professions Code. And oddly, I did not actually bookmark that. But what I do have, since I have the book out, I'm just going to skip a couple of those California statutes and go directly to the California Evidence Code, Section 660, Presumptions Affecting the Burden of Proof, because this was cited. It reads, the presumptions established by this article and all other rebutable presumptions established by law that fall within the criteria of Section 605 are presumptions affecting the burden of proof. You have all of these comments from the Law Revision Commission. I tend to skip that stuff, but this isn't very long, and it might explain why the next section is repealed. So in some cases, it may be difficult to determine whether a particular presumption is a presumption affecting the burden of proof or a presumption affecting the burden of producing evidence. To avoid uncertainty, it is desirable to classify as many presumptions as possible. Article 4, Section 660 to 667, therefore, lists several presumptions that are to be regarded as presumptions affecting the burden of proof. The list is not exclusive. Other statutory common law presumptions that affect the burden of proof must await classification by the courts. So that's the comment on the presumptions section affecting the burden of proof. The next section, Evidence Code cited, that was actually the middle section. That was 660. We're going to go to 664, which reads, now 661 was repealed. 662 is owner of legal title to property is owner of beneficial title. 663, ceremonial marriage. And 664, official duty regularly performed. It is presumed that official duty has been regularly performed. This presumption does not apply to an issue as to the lawfulness of an arrest if it is found or otherwise established that the arrest is made without a warrant. So this is just an example of a presumption that affects the burden of proof, and it's the official duty regularly performed. But see how it goes back to a warrant? This I find to be kind of interesting because we never asked for an appeal of a warrant before, but there was one circumstance when I definitely didn't like the look of it. Now, it may just be because in practice, it's not good practice to tell if you're in like a private firm to appeal a warrant, because that municipal court from there on after is like, oh, I don't like this person for having challenged the warrant that we issued. So it may be that that's why you're not going to win any friends that way. But anyway, I forgot to read Evidence Code 60. I'm not reading a lot of comments on that section. 600 reads, presumption and inference defined. Would have been good to have read that at first. And it's funny because I definitely have a card on this. And there's so much like emphasis on it. It's such a long section. There's only 2 parts to it, but still there's so much emphasis on this. A presumption is an assumption of fact that the law requires to be made from another fact or group of facts found or otherwise established in the action. A presumption is not evidence. An inference, this is B, second part of the definition. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts found or otherwise established in the action. Okay, so that's how California defines presumptions and inferences. So that's it for evidence code. I'm just trying to get back to where I wanted to be. I should be set. So we're done with that. We're going to the business code now. If you recall what I was saying, business and professions code before the civil code. So I didn't bookmark the civil code either. Done with evidence. Done with the California Constitution. That one's federal. Business and professions code. There's only 2 sections here. Some of it could be a little long, but let's find it. Let's open it. In order to find things, I create folders. And my folder is not here. So now there's a statute section under the search box in Westlaw, and I can just navigate down to California. It gives me these large subsections, such as starting with the Constitution. Business and Professions Code is here. Civil Code is here too. I don't know where I'm bookmarking and saving these things, but I'm going to open it up from this pretty easy to navigate to site and find section 6068. There's some divisions at this point, like in chapters. So I'm in like Division 8, Division 30. Division 30 seems predominantly repealed. And the sections there were like 30,000. So if I want 6,000, I'm probably going to Division 6 potentially. Like explaining this like it's talking to my contractors. Business rights. Yeah, I don't know. That sounds about right. Let's see what section. No, those are section 14,000. Let's try this one. Nope, that's 12. Let's try. I'm just kind of hunting and packing. Like division, I'm working my way backwards. Division 2, Chapter 6 on nursing. This section there begins with 2700. So I went too far. So now I got to go back to Division 3. Maybe Chapter 6 will take me to a section where the citations are in the 6,000s, but 6,500. So, backing it up, I see Chapter 4 in Division 3 pertains to attorneys. So this is probably more like it. Division 3 is provisions and vocations generally. Accountants, advertisers, architects, attorneys. Within this attorneys section, I'm going to, let's say Article 6, disciplinary authority of the courts. That's a little too far. Disciplinary, miscellaneous, disciplinary provisions. Still a little too far. Disciplinary authority of the Board of Governors. Still too far. Pro bono services. Okay. Too far. Contracts for legal services. Mandatory continuing legal education. Admission to practice law. Okay, this is where we begin. Duties of the attorney is the section that I am supposed to be reading. Part C in the Business and Professions Code. Duties of attorney. Oath is a section that actually just precedes this, and I took oath 3 days ago. So, interesting. So, for duties of attorney in section 6068, it is the duty of an attorney to do all of the following: to support the Constitution of the laws of the United States and of the state, to maintain the respect due to the courts of justice and judicial officers, C, to counsel or maintain those actions, proceedings, and defenses only as appear to him or her legal or just, except the defense of a person charged with a public offense. So I stop there because that is the citation that this book cited. So that's really all that needs to be said. But to give credence to my profession that I entered 3 days ago, I will continue reading. From the Business and Professions Code, Division 3, Chapter 4. So, whatever it was about attorneys. Yeah, I think it might be 4. And then pasting that in. So it would appear to me that there are A through O duties of attorneys. That's a lot of letters. And then under O, there's like another 10. Can I get this to read to me is the question, because that would be really neat. There's so many words. Come on. Can I get it to happen if I don't copy it? Read aloud.
Due to the
So I don't really need this to go any longer. Why is because has to do with disciplinary action by the state bar. The next section is 6,321 through 6,323. And since it will take me a little while to find it, I'm actually going to let her continue. Okay, never mind. Legal advertising. Oh, I'm going to go further. To find the citation for 6,321. It's not in chapter 4 pertaining to attorneys, because the end of it is attorneys providing Immigration Reform Act services. So we're going to go to actually chapter 5. And I read almost everything that's in that division. Division 3. Wait a minute. We are in Division 3. Having to do professions and vocations generally. I'm going to say law libraries, chapter 5 could be where we go next, or 5.5, or 6, paralegals. So let's keep on checking. It looks like it's going to be in the duties and power of boards, no. Law library funds, yes. Superior Court filing fees, distribution to counties and increases, as well as advance of funding upon certain conditions, amount and source, increase in amounts distributed to county law library fund from filing fees, board authority, time to distribute, reduction in filing fees, distribution chart for counties, and then the last section I'm supposed to read is actually repealed. So that one was repealed, the 6323. But the 6321 sections, starting with Superior Court filing fees, distribution to counties, and increases. This makes sense. Why it would be in the appellate practice book. Because believe it or not, these need to be included in your statement of damages, right? So we will read later. And we will get into that section. 72060. 720. Ah, I mean, really. Let's just go down here. I don't need to go into the amount distributed to the library. Blah, blah. Okay, so there you have it. That's basically the extent of this. Can I copy the section or is it not gonna- I'm just trying to copy the whole section. So help me God. All right, for the handbook that is. Which hey, you're gonna have to know how much you have to file your. What are we talking about? Filing each first paper or petition filing fee in a probate matter. Vehicle forfeiture petition fee. That's probably why we're later supposed to be reading from the vehicle code and the probate code. So this brings back to like, what does that mean financially for the appellate lawyer? There's just a very robust outline or very robust table of statutes and rules. What I'm seeking to identify, and maybe we'll see it in civil code because I've already navigated to the California Civil Code, have I not? I'm gonna get because we're moving out of business and professions code. Covered everything. Civil code is the next body of law that we are going to read, and I may just there's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 different citations. So I have a strong feeling that if we do not end in the midst of this code, we could potentially cover it if these sections are short. So let's just first read what is this? What is this act all about? Which is section 1. Yeah, let's do it for the sake of the benefit of later recordings. What is this about? Okay, it's known as the Civil Code of the State of California, has 4 divisions. Okay, so that's what this is about, the Civil Code. I dare to say that the section that I'm looking for is probably Division 1. I am wrong because, no, I might not be wrong. Trying to scroll down to the section. Okay. 131.5, repealed by later statutes in 1969. And then I see some things that I don't understand. C.1608 and P.3313. So that's probably the comparable to the Federal Register. So it's like California Assembly papers, let's just say. Full text document for this. Okay, I'm not reading it. It's been repealed. 133 has also been repealed. What were they about, right? That'd be nice to know. What was it about? They don't say. I have to open like a separate PDF. Whoa, wait a minute. Open a separate PDF. Personal relations. This doesn't have the full text of anything. Okay. $157. 157 is not even here. It just jumps from 150 to 164. Now, 227. I'm going to stop saying venture to say because findings to be wrong, although favorably wrong. 227. All of section 227, period, A, period, AA, AAA, period, B, C, D, E, O, P, 0.5, 0.10, 0.20, 0.30, 0.40, 0.44, 0.46, 0.40, 0.50, 60. All of it's been repealed. And we only had to read 227D. 227D, let's see if we can call it up so we know what the heck it was about, but it was repealed. Still, the section part 3 is about personal relations. I can't tell what more specifically it was about. So the next section that we're going to try to navigate to will be 1237, which is considerably later. Corporations has been repealed. Comes after corporations is, and it was repealed by a statute in 1947, or at least some of what was there was. Okay, in that section. Let's try Title 7. I don't know where to find the citations this present moment. I'm going to search 1237. I'm going to keep poking around. And what I'm looking at is just like a bunch of different types of businesses. Like corporations again was taken away. Bridge, ferry, wharf, shoe, pier, telegraph and telephone corporations repealed. Renumbered water and canal corporations, savings and loans repealed. Mining corporations, whatever. Corporations for the formation of chambers of commerce, mechanics institutes, boards of trade. I'm going to open this one up and see what the citation was. There really isn't one. Repealed 591 to 592. So I think this Division 1 about persons, Part 4 about corporations, Title 11A was also known as, 500 something. But we're trying to find Section 1237, which is considerably higher than that. So, I'm going to go back to expanding things and trying to find the right citation. But I got to find 1241. Everything's in the 1200s until I get to a 3400 citation. So this is obviously all corporations. Part 4, corporations repealed. Okay. Which is the end, which is the last title in the Civil Code. All repealed, right? So I'm not sure that I'm going to find a higher citation, a higher numbered citation. But here's a fair dealership law. Kind of actually remember writing a memo on this. So, but that's section 80. 80, that's not even a 3-digit number. I don't find anything. Yeah, but we're all in persons. Let's go to the next title about property, right? We heard there were 4 parts to this. This is all persons. Medical claims, data, error correction, that fair dealership law we were talking about, corporations. Okay. I'm in Division 1, so I need to go up a page. That could help me a lot. Okay, thank you. Division 2 is property. Let's go to obligations, contracts. Nature of a contract, chapter, definition. Okay, we're in the 1500s, so we went too far. Property in general, nature of property, that's 600. Real personal ownership, owners, 600 still. General definition, 700. Real or immovable property, 900. Personal and movable property, still in the 900s. Acquisition of property, transfer, unlawful transfers, 1200s. Okay, we're in the 1200. 37, very close. Okay, so the next section is Title 5, homesteads, which was repealed. And that might very well be, what I was supposed to read from. Repealed homesteads. Now, clearly, this is like, it's not actually that clear, but I'm gonna make an assumption that homestead determinations probably were appealable by way of this section, and that's probably why it's cited here. But if they are appealable today, it's just more likely than not that it's moved. Section 1241 is one that I was supposed to read as well. Still within homesteads, but also repealed. And repealed to what? Statutes in 1984. So, there's probably a separate real estate chapter. Okay. So let's move on. 1245 to 1259. 45 was repealed. 46 was repealed. 47 repealed. 48 repealed. 49 repealed. 50 repealed. 51 repealed. 52, 53, 54, 55, 56, 57, 58, 59, all repealed. Straight to 61, all still repealed. 62 through 64. repealed. 64 repealed. So everything in this homestead section is not going to be relevant. 3439, or at least anymore. 3439 is the next section I'm going to read. I want to move down to the general provisions. And relief in general. 3439, this is a little bit too far. Obligations arising from particular transactions. Ooh, let's look at debit cards. No, that's 1700s. So, COVID-19 landlord tenant. Okay, we have a pretty big gap. The gap is in Division 3 pertaining to, I believe, what, obligations? Yeah, Division 3 about obligations. The last section has to do with waivers under mortgages proceeding from the COVID-19 Small Landlord and Homeowner Relief Act. And that section is 3273. Beyond that, we jump to Division 4, general provisions, Part 1 about relief and relief in general. Oh, there's no gap because that's 3274. Okay, so let's go to compensatory relief, damages in general. Just so you know, relief, species of relief, relief in case of forfeiture comes before compensatory relief, damages in general principles, person suffering detriment defined, interest as damages, exemplary damages, measure of damages, specific and prevention relief, Uniform Single Publication Act, citation is almost right where we want to be, 3425. Interpretation, one cause of action recovery, judgment as bar, existing cause of action, Title V, Uniform Trade Secret Act, that's still too soon. Interference with access to healthcare, still too soon. Almost there. Duty of healthcare, service plans, and managed care entities. Part 2, special relations to debtor and creditor. Title I, debtor defined, creditor defined, marshaling assets, liability of lender, financing, manufacture, construction, repair, void or voidable transfers and undertakings. This sounds like we're getting close. Chapter 1, Uniform Voidable Transactions Act. This is what I'm supposed to read. 3439. There's a .01 definition section after a short title, insolvency value, transfer voidable as to present future creditors, factors to determining intent, transfer is voidable as to present creditors when transfer is made or obligation is incurred, remedies of creditors, defenses, liability, and protection of transferee, burden of proof, and extinguishment of cause of action, and governing law. They've renumbered section 11, 12 supplementary provisions, 13 uniformity of application and construction, application prior provisions and construction. So even though it's the last section, I might just read this application prior provisions and construction first. No, I should probably read this short title first. But this is all copy. The Uniform Voidable Transactions Act. Under Civil Code. Literally everything in civil code was repealed. There was a lot of homestead stuff that was repealed. There was some personal relation stuff that was repealed. What they wanted me to read was .07, which was remedies of creditors, and .04, which is transfers voidable as to present and future creditors. So that's all. Oh, actually, it said to go all the way down to 12. So we're going to read this whole entire section. But for the civil code, personal relations repealed. Just leaving notes in my handbook. Homestead repealed. This is Division 4. And Chapter 1. Let's see if we can't get the whole thing to be read to us. That would be fantastic. Might not work. Maybe it just might. It really won't. But let's get it to read the short title. She go over signs and stuff. I think she needs to stop. Okay. Come on. Next. The next section is about insolvency. Have her talk about that. Sure. So we need to go on the next thing we need to do is about value. Value is given for transfer an obligation if in exchange for the transfer obligation, property is transferred or an antecedent debt is secured or satisfied. The value does not include an made unperformed promise made otherwise than in the ordinary course of the promisor's business to furnish support to the debtor or another person. So the next section that we're going to get to transfers voidable as to present and future creditors. This is one that is highlighted in the table of statutes and rules for us to read. So, navigating to it, I want to ask a nice reader to read this section out loud. Wait, that's one of the next section. There's a whole section on defining what that means. I can read it in that greater detail. But I think the idea relating us back to appellate practice has to do with when a transaction is put aside and the other party's feeling the validity of that is was there a miscarriage of justice in making these factors willing to establish these factors, okay? That goes to the level of a miscarriage of justice or the standard of review for the fact of print set aside. Okay, so we are good with this section. We're good with this section. The next two sections really just elaborate on that section, um, definitions within that section. And so we move on to the next section, which is remedies of creditors, one of my particular favorites. Actually, I don't think so, because usually creditor might not stand for the bank. But let's hear it. Let's have me read it. In an action for relief against a transfer or obligation under this chapter, a creditor subject to the limitations of section 343908 may obtain avoidance of the transfer obligation to the extent necessary to satisfy the creditor's claim, an attachment or other provisional remedy against the asset transferred or other property of the transferee in accordance with the procedures described under Title 6.5 commencing with section 481.010 of Part 2 of the Code of Civil Procedure. Not actually cited here in the Code of Civil Procedure, but we will read about the Code of Civil Procedure after this section in another recording. So I might just note 481 here. As otherwise available under applicable law, subject to the applicable principles of equity and in accordance with the applicable rules of civil procedure, the following. A, an injunction against further disposition by the debtor or transferee or both of the asset transferred or other property of the transferee, appointment of a receiver to take charge of the asset transferred or other property of the transferee. C, any other relief the circumstances may require. B, if a creditor has commenced an action on a claim against a creditor, the creditor may attach the asset transferred or other property of the transferee if the remedy of attachment is available in the action under applicable law and the property is subject to the attachment in the hands of the transferee under applicable law. If the creditor has obtained a judgment on a claim against debtor, the creditor may levy execution on the asset transferred or its proceeds. A creditor who is an assignee of a general assignment for the benefit of creditors as defined in section 493.010 of the Code of Civil Procedure may exercise any and all of the rights and remedies specified in this section if they are available to any one or more creditors or the assignor who are beneficiaries of the assignment, and in that event, one, only to the extent the rights and remedies are also available, and two, only for the benefit of those creditors whose rights are asserted by the assignee. So I don't believe by creditor they're talking about the bank in that sense, number one. But number two, I think what I'm gaining from this chapter, from this section, the Uniform Voidable Transaction Act, what I'm garnering from this is that, like, the ability to repay if it's not quite established, like, or if there's nefarious business dealings, the agreed party could potentially set aside the transaction. And actually, that's a good enough explanation of what I think I believe is going on here. Defense is liability, blah blah. That's the next section. And protection of transferee, burden of proof. This is actually a rather long section. I might rest my voice for a moment. Okay, so the next section after 0.08 is the extinguishment of a cause of action. A cause of action with respect to a transfer or obligation under this chapter is extinguished unless action is brought pursuant to subsection A of section 3439.07 read above, or levy made as provided in subsection B or C of that same section. Under paragraph 1 of subdivision A of section 3439.04, not later than 4 years, also read above, not later than 4 years after the transfer was made or the obligation was incurred, or if later, not later than 1 year after the transfer or obligation was or could reasonably have been discovered by the claimant. B, under paragraph 2 of the subsection A of section 3439.04 or section 3439.05 read above, not later than 4 years after the transfer was made or the obligation was incurred. Notwithstanding any other provision of the law, the cause of action in this chapter with respect to transfer or obligation is extinguished if no action is brought or levy made within 7 years after the transfer was made or obligation was incurred. You're winding down. Next section is called Governing Law. A, in this section, the following rules determine a debtor's location, which is probably the situs for governing law. 1, a debtor who is an individual is located at the individual's principal residence. A debtor that is an organization has only one place of business is located at the place of business. 3, a debtor that is an organization has more than one place of business is located at the chief executive office. And B, under C, is a claim in the nature of a claim under this chapter is governed by the local law of the jurisdiction in which the debtor is located when the transfer is made or the obligation is incurred. That actually B after A in governing law. So the nature of the claim can be jurisdiction, local law of the jurisdiction determines governing law. Next section was renumbered, so I'm skipping that. There's supplementary provisions and uniformity of application and construction. So let's go back to the supplementary. Okay, supplementary provisions, they're telling you what is I see estoppel latches, fraud, misrepresentation, duress, coercion, mistake, insolvency, and other validating and invalidating cause supplement its provisions. And I get this from studying these equitable remedies. So unless displaced by the provisions of this chapter, the principles of law and equity, including the law merchant and law relating to the principal and agent, et cetera, like I just read, estoppel latches, blah, 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 or other validating and invalidating cause supplement these provisions. Okay, so we're not going to look at them in a vacuum and ignore principles of equity, which is so interesting for it to say it's being supplemented like that, but I like it. Last section is application. Construction. This chapter shall be applied and construed to effectuate its general purpose and to make uniform the law with respect to the subject of this chapter among states enacting it. It's like the most general statement I've ever heard. So that is everything that was cited in the California Appellate Practice Book, Table of Statutes and Rules for the Civil Code of California. And that was great. So we're going to have to follow this up with another 1, 2, 3, 4, 5. We already read evidence code. 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 more codes we're going to go into. But we already read evidence. Listen, honey. Good. And we already read Business and Professions Code. We've already read the Civil Code and the California Constitution in this recording.